The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. Your panel today, Judge Harris, Judge Keenan, myself, we are prepared to hear 3 arguments today. Looking forward to them, and we will begin our day with the case of Ziegler versus Eastern Chemical Company. We will hear from the appellant's attorney, Mr. Bogard, I believe?
Bograd, Your Honor.
Bograd, thank you for the correction.
You are not the first to mispronounce it over the years.
Trust me, I have a name too that you wouldn't be the first to mispronounce.
Is the mic in a good position for you here?
Yes.
Okay. May it please the court, Louis Bograd for plaintiffs' appellants Jackson, Van, and Ziegler. This appeal arises from a tragic industrial accident at a plant in Calhoun County, South Carolina, in which the plaintiffs, employees of DAC, were severely injured. The only issue on appeal is whether the district court erred in holding that it lacked jurisdiction to hear the plaintiff's personal injury claims against defendants Eastman Chemical Company and Mundy Maintenance Services.
Let's go right to it.
Sure.
Judge Childs felt that went one way on it, and now we have this case from South Carolina, the Supreme Court, the King case that looks to me to be key. Is it the key case here in terms of determination of the issue in this case?
Your Honor, I think the Keene case is virtually dispositive. The cases are, they're not identical, and we can talk about the distinctions, but they are virtually on all fours.
So I'm trying to cabin, at least in terms of where we are today. Normally we could go and we could spend a little time talking about facts, going all through it. We've done all of that. Looks to me we've got, unless my colleagues feel differently, a very keen legal issue here that arises from.
A very keen legal issue.
Does this particular case, in light of the facts before us, lead us in a different direction? And so if that's the direction you think is proper for this.
I wholeheartly agree, Your Honor. In our view, I was almost tempted to stand up this morning and say, in light of Keene, I'd like to let the other side go first, but that's not standard protocol on the Court of Appeals.
Need standard if it works.
Yeah.
Don't do it just for the sake of doing it. If you think that is something you can do, you can.
Well, I think I'll spend a few minutes outlining both the similarities and the differences.
Okay, and if I could follow in with just one question, what do you think that the South Carolina Supreme Court meant when it said what is or is not part of the owner's business is a question of business judgment, not law? I mean, that seems to be a very marked departure from all of its prior holdings in this area. What does that mean?
Well, first off, Your Honor, I will answer that question directly, but I think it's not a marked departure. As the South Carolina Supreme Court itself said, starting with Bridges in 1963.
Oh yeah, they tried. I don't want to say they tried to argue that it wasn't a marked departure, but it seems to be a departure from the 3-part test, does it not? Why isn't it a departure from the 3-part test that they had articulated over the years?
It's not a departure from the 3-part test for a couple of reasons. First, this is a question of statutory interpretation, and what they were saying is that the 3-part test was a judicial creation to interpret the meaning of the South Carolina statute 42-1400, South Carolina Code 42-1400, and that in some ways the shorthand phrases of the test had taken the focus away from the statutory language, and that they were recasting the tests in light of the language of the statute itself. It's the statute that talks about whether the, sorry, I'm just trying to pull up the language here. It's the statute that talks about whether the owner undertakes to perform or execute work which is a part of his trade, business, or occupation.
Right, and the court seems to be shifting its focus to the business owner's intent and whether the business owner is trying to avoid the cost of insuring workers, isn't it? And these aren't hostile questions. I mean, I'm just interested in.
I'm not, and I am not perceiving them hostilely, Your Honor.
Okay.
The fact is, this has always been a very fact-intensive inquiry because, as a number of the opinions say, and I'm not going to remember which ones, what is a part of a multinational corporation with thousands of employees might be a very different question from what is a part of the business of a small firm that only employs a dozen people and needs to bring in outside contractors to do a lot of its side businesses. So it's always been a question of what are the particular facts and circumstances of this business and the relationships between this business and its contractors. And what the court said is, fundamentally, we are going to look at this question of what decision did the company itself made about what is its business. And we have been arguing in this case from the beginning, and unfortunately we didn't have the benefit of the Keene decision to present to Judge Childs, although we did have the Court of Appeals decision on reconsideration. We've been arguing from the beginning that since 2011, when Eastman sold its plant to DAC and essentially eliminated its entire workforce, transferred its workforce over to DAC, that it has not been in the business of producing specialty chemicals. It has not been in the business of maintaining production lines. It has not been, none of those things have been a part of its business because it only had 3 or 4 employees at the plant who were all managers to liaison between DAC and Eastman. There was no, they had no production staff, they had no maintenance staff. They had made a business decision to exclude all of that from their work. And I think if you go to the key quote from Keene, which talks about, which asks 3 questions, right? Does the company believe its workforce is not equipped to handle a certain job? Well, clearly here, they had no workforce that could handle this job. They only had 3 employees. None of them were engineers. None of them were maintenance workers. None of them were production workers. So the company clearly believed it did not have a workforce that could do this work itself. That's why it signed.
Judge Keenan's question to an issue that may arise if we, and the King case is the law of South Carolina. So only the interpretation is how it is applied in this case. But should it be retroactive if we decide to take it, or would this approach impose a liability on Easton and Monday where none had existed before?
Your Honor, there's no question it should be this case should apply retrospectively, and I'll give you, I think, 4 reasons for that. First, the precedent on this issue is very clear. Judicial decisions are presumptively retrospective and apply to pending cases. The only exceptions are when the court creates a new cause of action or abrogates an immunity. Neither of those things happened here. They did not abrogate an immunity. They clarified a test, and we didn't brief the retroactivity issue because we filed simultaneous supplemental briefs. But if you look at Lord versus D&J Enterprises, 757 Southeast 2nd 695, Carolina Chloride versus South Carolina Department of Transportation, 391 South Carolina 429, or Miranda C versus Nissan Motor Company, 741 Southeast 2nd 34. Each of those cases talk about this basic body of law, and that when all the court has done is clarify, refine, refocus, evolve a test, it applies retroactively. It's only when cases or immunity doctrines have been abrogated that they have been applied prospectively only. And the cases cited by the other side in its supplemental brief are not to the contrary. They cite 2 cases, Hupman and Brown, both of which involve the abrogation of charitable immunity. So yes, indeed, the courts recognized that charitable entities that did not maintain liability insurance needed time to adjust to this new doctrine. So those should be applied prospectively. and they cited the Toth case, which is a case that was applied retrospectively. It's interesting in this regard, Your Honor. Well, one last point to go back to what I was saying to Judge Keenan a minute ago. This is not a new doctrine. Yes, we have not had as clear a statement from the South Carolina Supreme Court previously as we got in Keene. But as the court said, you can look at most of the decisions since 1963 and find a consistent pattern of deferring to the business judgment of corporations, of the corporations involved, and whether they thought something was part of their business or whether they outsourced it. So this is not a new rule. This is not something that should have come as a huge shock or surprise to Eastman or to Monday.
Maybe not a new rule, but it certainly appears to be a departure of some nature. At least the King case did make out that the three older tests remain valid considerations. What do you make of that? Are we supposed to then go through each one of them, or did King basically supplant those tests?
I don't think so, Your Honor. Your Honor, may I make one more point of retroactivity before I answer that question?
Move on.
I just wanted to make one last point, speaking to retroactivity. Mr. Bogan, my opposing counsel today, represented Celanese Hoekst in the Keene case. And when they moved for reconsideration in Keene, they specifically asked the court, even if you're not going to change this decision, at least make it prospective only, because this will upset all of our settled business expectations and the like. And the court denied reconsideration. Exactly the same thing happened in the Miranda case I just cited. Not in Miranda. The predecessor case to Miranda was a case called Branham that had changed the rules regarding design defect cases in South Carolina. And plaintiff's counsel in that case didn't like the new rule and asked for reconsideration to make the case prospective only. And reconsideration was denied when the same counsel then brought the Miranda case against Nissan and tried to argue for prospective only application.
To making decisions from here, what counsel argued, one way or the other.
What I'm saying is the court deemed it significant that the Supreme Court denied reconsideration despite being asked explicitly to change the rule to make it prospective only.
I'm not sure that carries in it much. You know, the fact you deny something and don't affirmatively state it. But let's move on.
Let me go to your question.
Consider this.
Yeah. So the three tests. I think I don't know entirely what the court meant by saying that the three tests remain valid considerations. You know, I don't think you need to go through them. I think the key test is the test articulated in Keene. Did the company make a business judgment this wasn't part of the case? But I think what they were really doing was looking at those three prior tests and saying, you can consider all of these factors. The first one was, is it an important part of the business? That was test one. Well, and Keene is saying the key word is it part, whether important or otherwise. The second test was, is it an essential and integral part of the business? Again, part was part of the test. And the one that I think is most confusing is the third test, which is the one about whether the work has been done previously by the company's employees.
And it had it not? And it had.
Well, yes and no, Your Honor. That test derives from the Bridges case. And I think that the defendants have been trying to read a lot more into that test than it can bear. The third test is this work usually or customarily performed by the defendant's own employees? In Bridges,
I thought the quote from the Pope case, POCH, was had it previously been performed?
That is, I understand that is the language in which the test is usually described. But if you go back and read Bridges, which is the case from which that test derives, Bridges was a case where the company had its own electricians on staff who could do all this work, but they had been overtaxed, and because the work needed to be done on a holiday weekend, they decided to bring in contractors because they didn't think their own staff could do more overtime. So it was sort of a temporary replacement workforce. And the court said in that case, clearly the company had made the judgment that normally electrical work was part of their business. That's not this case. Here, the company in 2011 made an explicit decision we are never again going to be doing production. We are never again going to be doing maintenance. We are putting all of this way behind us. We are selling this business and transferring all of our employees at lower salaries and the like to this other company. We're getting out. And once they made that decision, it can't be the case that the fact that at some point 10 years earlier, 15 years earlier, 100 years earlier, a company did something that it no longer does, that they are forever barred from changing the nature of their business and therefore changing the nature of the test.
Counsel,
So
in terms of
I think, I'm sorry.
In terms of what we do with the three-prong test, which the court does not overrule, I mean, is the right way to think about it, is this what you're saying, that we might look at those three factors sort of in applying the standard that comes out of Keene? They might, as in the Bridges case, they may shed some light on whether this is being done for a legitimate business reason or whether something else is going on here, but that we would have to sort of run them through the Keene standard.
I see I've just run out of time. May I respond to that question? I think that's exactly right, Judge Harris, that the court didn't want to say, because the court was saying this is not a new doctrine, this is an evolution of our existing doctrine. The court said, you can look at these questions, how essential to the business is it, how important to the business is it, is this work normally performed by the company's own employees? And those may factor into your application of the Keene test and into the question of whether these workers are doing something that the business itself thinks is part of its business. But they aren't independent grounds for us finding statutory employment if the Keene test is not met. And I'll reserve the rest of my time for rebuttal.
Thank you. We will hear from the appellee in this case. Mr. Bogan?
Thank you, Judge Wynn, Judge Harris, Judge Keenan. My name is Matt Bogan. I'm here today on behalf of Eastman Chemical, and I want to address each of the questions you asked my brother at bar. But first, I would like to start at Joint Appendix page 269 and 270, which is Judge Child's order on rehearing. And timing here is important. If you'll bear with me for just a second, it's like a train passing down tracks as these cases are going along. Judge Childs ruled in our favor, dismissing the case, saying we had statutory immunity. Keene came down from the Court of Appeals. Rehearing was sought there. They sought rehearing based on Keene. So May 13, 2019, the South Carolina Court of Appeals denies rehearing in Keene and says Keene is not covered. I mean, Keene, no immunity for host Celanese CNA holdings under the tort claims, under the workers' comp statute. 7 days later, May 20th, with sober eyes, full eyes on Keene, Judge Childs recognizes and says this is distinguishable. I'm finding that Eastman previously did this work, and I'm finding that this case should be dismissed, and Eastman and Mundy are entitled to immunity. So 269, 270, that's the starting point. And I start there because it's an anchor point, because the Supreme Court in South Carolina affirmed in toto the Court of Appeals. Now, they have some different interesting language, Judge Keenan, that I'm not sure exactly what it means. I'm going to do my best to try to give my thoughts on it if the court asks about it. But here's the thing. The outcome didn't change. And Judge Childs, in a learned opinion, was aware of it and found this is distinguishable. And the facts do matter. Our Supreme Court has steadfastly said it's a case-by-case decision. In this case, has to be decided on its facts. And I'll talk, Judge Wynn, as much about facts as you want. I'll talk as much about the Keene case as you want. But I think we win this case in two different ways. Number one, Judge Childs had it right. Keene didn't change it. You look at the test.
Let me make sure I understand the pattern here. You cite the
Yes, sir.
South Carolina Court of Appeals case.
Yes, sir.
That was the Keene case, and then the South Carolina Supreme Court heard it thereafter?
Thereafter, yes, sir.
And what do you make of the Court of Appeals case?
That the outcome was affirmed in toto. So
What does that matter if the Supreme Court of South Carolina subsequently rules on the case?
Your Honor, I think in terms of, I'm trying to make a practical point that Judge Childs was not without the benefit of.
We're not putting Judge Childs on trial here. We're simply trying to determine the law of South Carolina.
I understand.
And it is very clear I sat on the Court of Appeals in North Carolina for a number of years. I wish I could elevate the opinions I wrote above those of the Supreme Court, but it's pretty clear. We only going to look at that South Carolina Supreme Court opinion.
Yes, sir.
But I'm not trying to be argumentative. I'm trying to get because you could persuade us otherwise. I'm trying to understand what is the import of a Court of Appeals opinion, even on the district court there, if she's ruling consistent with it, and the South Carolina Supreme Court issues a subsequent opinion. Why in the world would we look to see that? Judge Childs, I would agree. She probably acted reasonably within what was going on with that opinion. She did not have the benefit of the Supreme Court of South Carolina opinions, did she? So that's what we're really talking about, right?
Fair enough, sir. And let me.
But I don't want to just be fair enough. I don't want to brush it aside.
No,
I think it's a focal point. I want to move your argument.
I'm going to dive right to it.
You address this question. Does the Supreme Court of South Carolina's opinion in Keene change or impact this case, and how so? Irrespective of the Court of Appeals opinion, which, as I said, I have a lot of respect for that court because I was on it, but I know this is the final court. So give us the final opinion and how it impacts this case.
It doesn't affect the outcome at all. The outcome is still the same. We're entitled to immunity under the statute. And my point practically with Judge Childs was she didn't see into the future, but her analysis is still the same even under the Supreme Court's final decision in Keene. And here's why, for 2 points. If you look at record, Joint Appendix page 756, that's the annual statement of Eastman Chemical, which shows it is in the business of making specialty chemicals, right? It's PET, it's plastics, hot plastics that come out that go make coverings on V8 bottles that you buy in the grocery store. And at 756, it shows that our AM segment, which is the advanced materials segment, which ties in Doug Reister's deposition, we're in the business.
Tell me this. How did Keene change, or did it change at all, this test for assessing the scope of the statutory employee doctrine? Do you think it changed it at all, or you think it's just this, it didn't do anything?
What, Judge Wynn, it certainly was a long opinion that Judge Few authored, and it has to have some meaning, so I do think it had to in some way change it, but I don't think it changes the outcome of this case because it's
It was
still
a long
factual.
opinion about nothing. It was just this, he could have just affirmed the Court of Appeals opinion or whatever. Is that what you're saying?
No, sir.
You're saying it didn't, because it seems,
No, sir,
I mean,
I'm not.
I thought we were going to start at a point that at least it did something.
I think it probably narrowed it, but it doesn't change the outcome in my case.
Okay.
I mean,
Can I ask you a
It's
question,
just
counsel? So the standard, as I read Keene, after Keene, is that if there's a reasonable business case for contracting out, if a company's own employees aren't equipped to do the job, there's some other good business reason why you would want to contract out, and it's not done for the purpose of avoiding the costs of insuring and liability, then it's not part of the business anymore. So which part of that standard do you think you win under? Because I don't see it. Like there seems to be a reasonable business case. They sold most of their holdings. That seems like a reasonable business case at that point. They've only retained a few managers. They don't have, and I don't believe there's ever been an allegation that this was sort of a bad faith effort to kind of get out from under liability for insurance. So under which part of that standard do you think you prevail?
Well, yes, ma'am. Here, the DAC plant, that was the transaction that happened in February of 2011, Eastman retained 4 lines at that plant.
13, though. It's sold 9.
Yes, ma'am. So it had 4 there and chose to employ it through subcontractors with DAC.
So you think there was either no legitimate business purpose for doing that, or it was a subterfuge, the whole sale, the whole thing was just a way of getting around insurance liability?
No, ma'am, I don't think it was either one
Well,
of
if
those.
it wasn't either of those, how do you prevail under Keene?
Well, we still were previously in the business because that still exists, as Judge Keenan pointed out. But I want to answer your question, Judge Harris, on this point, that here, different than Keene, we were co-insureds on the insuring agreement. That was not true for Daniel Construction.
I guess
post-Celanese.
I may not be framing my question right, and I will just try one more time to clarify. So as I understand it, and maybe you disagree with my summary of the Keene standard, but you can prevail if one of 2 things is true. There's no reasonable business case for contracting out here, and or it was done for the purpose of avoiding the cost of insurance. And I'm just asking you, under which of those prongs are you arguing?
Oh, Your Honor, I guess we do disagree in that I don't know that that's the outcome determinative factor test on that, because you have to look at whether it's part of the trade.
You're not arguing that either of those things is true here?
No, ma'am.
Okay.
And so trade, occupation, and business is the question. That's what Justice Few, in his opinion, and Keene said. And he went back to the 1939 case of Marchbanks, which looked at trade, occupation, or business. And our trade, occupation, and business at Eastman is making specialty chemicals. And we're still in that business here. And different, and all across America, in different parts of the world, we're making these. Here, we do it with DAC employees who we cover under a workers' compensation regime. And we're co-insured on the policy. That's different than Daniel and CNA Holdings. But I do think, Judge Keenan, to your earlier question, it is important that we previously did this work prior to February 1, 2011.
Well, I think that's kind of the heart of where you seems like your argument is. You seem to say, well, you say that the Eastman employees previously performed this maintenance work before 2011 sale to DAC, that is still part of the Eastman's business 5 years later. So, I think that's kind of a conundrum for us right there. Straighten that out, because it seems to me that there was an outsourcing of that part of the business when it was sold, when it sold the plant and hired DAC. And so the question is, any evidence in the record that suggests that outsourcing maintenance work to DAC was not a legitimate business decision?
And that goes back to Judge Harris's question, and maybe I'm...
But no, don't go back to her question, go to that question. Is there any evidence in the record suggesting that the outsourcing maintenance work to DAC was not a legitimate business decision?
And I hate to ask the court a question, but I guess I don't understand the question, because it was...
Well, maybe you don't understand the question, but the answer is what we want to hear.
And
And then you can walk from the answer. Either you say, yes, there's a legitimate business reason, or there's not a legitimate reason. So that's a simple question.
Well, I think the parties contracted, and it was a valid, lawful contract, so it has to be for... I mean, I don't know, it couldn't be illegitimate. That's why I struggle with the question. And Your Honor, I know that may not benefit me answering it that way, but one, it's truthful, but I don't think it's dispositive of the issue, because they had operating and servicing agreements, which they contracted to have DAC employees do this work on lines owned by Eastman. It's still in the trade, occupation, and business of making specialty chemicals. And it's not trying to avoid or do anything harmful. Instead, unlike Daniel and host Celanese in the Keene case, we were co-insured on the policy to provide workers' compensation benefits, taking refuge under 42-1400 of the code. And I think we still passed the test, and I think it's fact-dependent. I think those facts really matter. I know the Keene case came out, and it looked like it narrowed. I mean, it has meaning, narrowed, made it harder, but we still qualify. And I think that's why I started with Judge Child's point, whether by forecasting or accident, she still got it right, because we're in this business. And the outcome's still the same no matter Keene, at least in my estimation. And those lines are essential to making the products we sell to clients, to make the shrink wrap that covers the V8 bottles that we sell in that are sold in grocery stores, right? So, and those DAC employees operating and maintaining that line have to keep it going so we can make those products and sell them to the client. And we own those 4 lines. And I think that is vastly different than the facts of the Keene case, where you had host Celanese is in the fiber business, in the textile business. Daniel Construction is in the construction business and is there maintaining lines and doing things at the Celanese plant. And it's two different things. Here, it's the same business. It's operating and maintaining the line so they're running. So it's vastly distinguishable from Keene.
Your points are well taken, but I think it's all a determination of how we interpret what Keene is. If Keene changed things differently, and it does say valid considerations for the 3 tests, but Keene itself didn't even go through the 3 tests itself. It seems to have created something differently. You are constantly pushing the 3rd part of the 3-part test, the activity has been previously performed by the owner's employer, from the 3rd test that was there. The question is that still part of the standard for this. And if you go in the direction you're going, you're right. You're going to go on and tell us how this previous was. But if the law is interpreted differently in terms of the case itself, that's really not going to matter. You argue the case, had King not come down, that as it would have existed. So where we're really splitting on it, and because I don't want you to miss the opportunity, if there is an opportunity here, because if there's an opportunity to undo some confusion here, and that is the impact of the King case and what did it do? Because that's where we start, is what the law is. We don't start with what it was, but if you only think King was just a minor tweaking and did nothing to the statute, then that's one thing. But if the other side think it creates a different type test and brings out a different kind of outcome, that's another thing. My point is, focus on the law, and then we can get the facts. You see what I'm saying? Because I don't want you to spend time. I can let you just go on out of courtesy, just talking about this previously employed, but it's not doing you a favor if you're not articulating why that law is what it is, based upon King.
Yes, sir, and I'm sorry I went to where I have a minute left to do that, but thank you, Judge Wynn, for the guidance to get there. It's my estimation that the Keene opinion did not change the outcome in this case. I am not sure, but I have to trust the words of our state Supreme Court that said it didn't overturn those decisions and the three-part test still exists. It's probably
But
hard.
it didn't use it itself. They didn't even use those three tests in deciding King.
Because it didn't need to based on those facts, because it's still case by case would be my estimation, Judge Wynn. But I know we don't want to talk about facts.
Can I ask you a question? You know, what we make of the pre-existing three-part test and the kind of prior activity prong after Keene, the one thing that I really have trouble reconciling, I guess, with Keene would be the idea that because before the sale, Eastman's own employees did this, that means sort of now, many years after the sale, Eastman can't make a business judgment that they would like to change whether they use their own employees or not. I'm not explaining this right. Your version of the prior activity prong seems to mean that once a business originally decides to use its own employees for some purpose, it can never outsource that again, because it will always be the fact that it was previously done by their own employees. They fail under the third prong of the pre-existing test, case over. And I have a lot of trouble reconciling that with Keene's, whatever we think Keene did or didn't do, the huge emphasis on business judgment and allowing businesses to make judgments about what they want to contract out and what they don't want to contract out. How do I reconcile that with a rule that would sort of freeze in place the original business decision? Is that clear?
Yeah, thank you, Judge Harris. Judge, when I see I'm out of time, may I continue?
Of course.
Thank you, Your Honor. Judge Harris, I would point to the quote from the Keene case that says, "We're trying to prevent owners and contractors from subcontracting out their work to avoid liability for injuries
Well, I
incurred."
already asked you whether you were even arguing that that's what happened here, and you said no.
Well, that's why we had an insurance agreement to cover for workers' comp. We weren't trying to avoid that liability. We provided for it. That's my very point. Through the operating agreement, we were the insured on the workers' comp insurance agreement.
Here's the question on that. Where do you draw the line on when the work is no longer considered previously performed? Where do you draw that line?
So the limiting principle there, Your Honor, that I would identify, it's going to be fact-specific, and I don't know if it is time, but I think it has to go to what the trade, occupation, and business is. That's what Justice Few is focused on. So it's dependent upon that. And in instances like the power pole case, which I think was the Bridgers case, where they were painting the power poles and they didn't have enough employees to do that at the time, and they hired somebody to come help the team, that was work previously done. That fit the fact pattern. So I do think there are limiting principles. I don't think it goes out into infinity, Your Honor. How this court draws those lines, I think it has to be case by case, and I think it has to be fact by fact. And Your Honor, I don't want to go out of bounds with, you've been generous with the time, but if I might wrap up, unless there's other questions, which I'd
Go ahead.
gladly.
Well, you do have a few minutes in rebuttal. Do you want to cut into that?
No, Your Honor, I don't have any rebuttal. Mr. Munson has 5 minutes for Monday.
You want to trust him to carry on that point for you?
I trust him very much, sir.
He
but I
can
just-
yield some time to you.
I just wanted to wrap up and say this. We think this court should affirm Judge Child's decision that even in light of Keene from the Supreme Court, it remains correct that Keene did not change the outcome in this case. It may have made it harder to qualify for statutory employment, but we still do. In secondary, I'll rely on my brief on retroactivity. We do not think that, we think this is a change. It takes away our immunity. It would. If you all say Keene, you don't get protection of the workers' comp provision, which we contracted for and bought insurance for, to avoid that liability, then it can't be applied retroactively. That would be our position. So we ask you to affirm. I'd be happy to answer any more questions, and thank you for your time today.
Thank you, Mr. Bogan. Mr. Munson.
May it please the court, I represent the defendant appellee Monday Maintenance Service and Operations, who is a bystander in this case. Eastman Chemical had this project. They needed a blowtorch. They didn't have a blowtorch.
What do you mean, no bystander? Does it mean you won't have any, it won't impact you one way or the other, or bystander from the factual perspective?
Factually, we're a bystander.
A
in this.
bystander who got touched by the water that was being splashed, right?
Yes, Your Honor. The Eastman needed to borrow a blowtorch. They didn't have one. They called Monday, do you have a blowtorch? They didn't have anybody to operate a blowtorch, so they borrowed a blowtorch. They borrowed Monday employees to come over, run a blowtorch on a drain line that happened to be adjacent to this pump. That's the center of this litigation. Monday's statutory immunity doesn't arise from being a statutory employer. The statute provides immunity for statutory employers and also for those doing the work of the statutory employer. That is the basis of Monday's immunity in this case. Its employees who were borrowed, Judge Childs found to be the fellow co-statutory employees with the other workers involved in this project.
Is the issue regarding your client simply whether you it is shielded by the borrow-servant doctrine? And if we say, you know, that's something that's relevant here, shouldn't we just send this back for the trial judge to determine if there's enough evidence in the record to support that defense?
That would be an appropriate response here, but to say, no, you don't need to do that, here's my reasoning. Originally, Judge Childs did not dismiss Monday, so we had to move for reconsideration. For her to dismiss Monday, she applied the standard of clear legal error, manifest injustice. In doing that, she agreed that it was clear legal error for her not to cloak Monday with the immunity under the statutory employer standard that was given to the employees. Basically, respondeat superior being cut off as to the employees doesn't rise to Monday. That was her clear error that led to dismissal. On the borrowed servant doctrine, she's still operating on a motion for reconsideration, a clear error of law standard, and she found that it did not, quote, require reconsideration. To put that in college football parlance, she didn't confirm the call, she just didn't overturn it. Now, when it comes here...
But how did it come here? Did you take a cross appeal on that?
No, Your Honor. It is here because I'm arguing that in the record, which was fully developed and argued below, this is an other sustaining ground.
We can't affirm on a ground that the district court rejected unless there's a cross appeal, right?
I will leave that to you, Your Honor. I can't say either way. What I would say is that she applied a different standard.
Don't go by that. That's a critical point right there.
I don't know the answer to that,
That's
so...
a killer. What you just heard right then, you need to address that.
My response to that would be that the standard that she applied is different than the
She's
standard.
talking about the effect of a cross appeal.
I understand,
How
Your
that
Honor.
works in here. If you didn't do it, and I understand you want to argue, but we don't need to hear an argument. It's theoretical and interesting if the rules are going to point us totally different in terms of it. So I posed the question from the beginning that even at best, what we would do is send it back to the trial judge to see if there's evidence. You're trying to convince us we ought to do it because there's something here to do it. But the question is, how do you bring that now without having brought a cross appeal?
If a cross appeal is a prerequisite to that, I agree and would say it should be returned to the judge on the issue of the borrowed servant
We'd
doctrine.
hope you would known that before, we don't want to get up and say things like that it is a prerequisite or whatever, even though we may know the answer to it. But I wanted to point you in that direction because, as I said, it's nice to hear things said, but sometimes when you're talking to the appellate court, they'll let you just run on and just talk. But it's not really hitting anything. And I know you want to hit something.
Yes, Your Honor.
I want you to make a difference with your argument.
And Mr. Munson, I am concerned about the fact that Judge Childs did say the record lacks sufficient evidence for the court to consider the second, third, and fourth prongs of the borrowed servant doctrine, referring to page 282 of the appendix.
Yes, Your Honor.
So how, it seems to me that if we do disagree with regard to the impact on Keene, that is, disagree with Mr. Bogan, then don't we have to remand the Monday for the development of the record on the borrowed servant doctrine?
Your Honor,
And if not, why not?
yes, the only reason would be that the standard, she used a higher standard in this court on sustaining on another ground, does a de novo review based on what
Well, no,
appears in
I'm
the
saying the
record.
district court herself said there isn't evidence in the record as to the second, third, and fourth prongs of the IDI test. And so how do, if we disagree with your fellow counsel, how do we do anything other than send it back?
Her statement was that it didn't require reconsideration, which is a different standard than could be applied. That's the only basis I have.
Judge Childs didn't have to develop the record because Monday went out under the fellow servant doctrine. Isn't that correct?
That is correct, Your Honor.
Okay, so she didn't have to get to borrowed servant. But now, if we disagree, and that's a big if, but if we disagree that Keene didn't change the landscape, then we have the borrowed servant doctrine bubbling up to the top that needs to be addressed. And the district judge herself said the evidence is insufficient on this record. I'm not getting to it. So how do we decide that borrowed servant issue in the first instance when the record lacks details of furnishing of method of payment of the employee, the right to exercise control, the furnishing of equipment, the things that the judge said just weren't in the record sufficiently to make that determination?
It would only be because in finding another sustaining ground, it's a de novo review. That is all, Your Honor.
All right.
Thank you.
Judges? Thank you very much for your argument. Mr. Bograd, did I get that right this time?
I'm sorry, Your Honor, that Mr. Bogan and I have such similar names. I'm sure it's complicating.
I don't think either one of you had anything to do with that, so we're good.
Counsel,
Thank our mothers and fathers.
could we start with the question I just posed to co-counsel regarding the borrowed servant doctrine and Judge Child's observation that the record was incomplete?
Your Honor, I think that's absolutely, you're absolutely correct on that.
So you agree, if we agree with you, you further agree that it does have to go back on the borrowed servant doctrine?
The grounds on which Mundy was dismissed was under the fellow servant
Right.
test. If you rule in our favor on the statutory employee issue as to Eastman, then the plaintiffs and Mundy's employees are not fellow servants, and the decision as to them needs to be reversed. Whether I believe the borrowed servant doctrine is actually not a doctrine of jurisdiction, but a doctrine of liability, and therefore they would be able, presumably be able to litigate it when we go back on the substance of the case. But clearly the decision as to them needs to be reversed as well, because we can't be fellow servants if our employees are not statutory employees. But I'd like to respond to some of the arguments made by Mr. Bogan. First, he made a big point of saying that Eastman Chemical Company is in the business of making specialty chemicals. I think that's disputable, at least at the Calhoun County plant, where they didn't have any employees to make specialty chemicals. But this is not a case about production. This is a case about maintenance. These were maintenance employees, and certainly Eastman is not touting itself as in the business of maintaining chemical plants. And that's where I think Mr. Bogan made an important error of fact that the court needs to focus on. The agreement with DAC had two subparts, the operating agreement and the services agreement. You can find them both in the joint appendix, the services agreements at JA 400, the operating agreements at JA 453, and they both go on from there. It's the operating agreement which covered production that specifically talks about this leased workforce to produce specialty chemicals at the plant. And it's the operating agreement that says DAC has to maintain workers' compensation insurance, needs to name Eastman as a co-insured, and that Eastman will be considered a statutory employee for purposes of workers' compensation law. The services agreement, which is the agreement under which all of the plaintiffs were employed because they were not part of the leased workforce, they were not production workers, says absolutely nothing about workers' compensation insurance. There are just no provisions about it whatsoever. Now, I'm not trying to suggest that Eastman was trying to avoid workers' compensation. I'm saying that all of his discussion about the contractual terms under which they sought to be specifically identified as statutory employer of workers at the plant refers to the production workers, not to the plaintiffs here. I've already spoken about Mundy. I also think in this regard it's important to note something that the Keene Court says about public policy and the public policy behind the statutory employer doctrine. The court is very clear that the applicable, and this is a quote, the applicable public policy, however, is to ensure that workers are covered under the workers' compensation law. It does not matter to the fulfillment of this policy who provides the coverage. And there's no dispute here that DAC did maintain workers' compensation insurance. Indeed, each of the plaintiffs has recovered workers' compensation from DAC. The independent question of whether they may sue in tort against Eastman and Mundy is an independent question. And as to that question, Keene said as a matter of public policy, the public policy at issue here is not to provide civil immunity to companies like Hearst or their corporate successors like CNA Holdings. But I'd like to close with this point, Your Honors. This court clearly recognized 2 years ago the significance of the South Carolina Supreme Court taking the Keene appeal when it placed this appeal in abeyance. And it placed this appeal in abeyance until the South Carolina Supreme Court rendered its judgment in Keene. It took a lot longer than we wanted. There was the reconsideration petition and all. But this court sat on this appeal for 2 years waiting for the South Carolina Supreme Court to decide Keene. The South Carolina Supreme Court has now spoken, and its decision makes absolutely clear that plaintiffs were not Eastman statutory employees under the test announced by the South Carolina Supreme Court. For that reason, the district court's decision to the contrary must be reversed. Thank you.
Thank you, Mr. Bograd. Thank you, counsel, on both sides. Appreciate your argument. You know our usual tradition here. You've seen it many times. We typically come down and shake your hands, but these are difficult times, and we think the risk exceeds the benefit of doing so here continually. But we wish you all good health, and thank you for having been with us today. We will now move on to the second case on the calendar. All right, we'll hear from the appellate's attorney, Mr. Rainsbury.
Good morning, Your Honor, and may it please the court, Joe Rainsbury, representing the appellant and the cross appellee, Messer LLC. This is a UCC case involving a long-term requirements contract for the provision of industrial gases. It was originally signed nearly a quarter century ago in 1998, but this particular dispute concerns the 2008 addendum. And the focus of the dispute concerns the price escalation provisions in the contract. Now, the 1998 original contract had two provisions that addressed price escalations. The first provision, which was the standard
I mean, if
form-
this isn't a simplification of the facts, you got a contract 1998, then you do an amendment to this
Yes, sir.
contract that has a term of years on it. After that term, you continue to operate as though this first contract didn't operate, and ultimately, the other side decides, wait a minute, we've got this first contract from 1998, and we shouldn't be doing this, and start objecting. And the question here that we now face is, was the original contract still in place at expiration of the 5 years? Is that it?
Yes, sir. I think you've characterized
You think it was?
the issue very well.
Convince us of that.
I'm sorry?
Convince us of that. Why that?
Yes, sir.
Why a contract under this particular law would still be in effect, even though it had a term of 5 years, and under applicable contract law and interpretation of how we would do
Well,
it?
we've got two arguments. And the first argument, I think, is a very straightforward one, which is just that under ordinary principles of contract amendment, when you amend a contract and you put in place a term that is inconsistent with the original contract, then you create a new contract. And that contract consists of all the terms that were unchanged plus the new terms. And one of the terms that's inconsistent, one of the original terms that's inconsistent with the 2008 addendum is this 2% price escalation cap. Clearly, the parties found that this wasn't working. And in 2008, they completely renegotiated the prices. They eliminated the 2% cap, and they said, well, we're going to extend the contract for 5 years. For the second year, there's going to be a 9% price escalation cap, and for subsequent, the third, fourth, and fifth years, there's going to be a price escalation cap of 8%. And what the parties didn't do is they didn't address the contingency of, well, what happens if we agree to extend the contract?
In other words, they didn't retract that 2% contract, the cap.
Well, they did.
Years other than those that are specified in the addendum. They did not retract that, did they?
Well, Your Honor, I would say that the provisions that they agreed to in the addendum were not consistent with the original 2% cap.
I'm only, understand my question, which, don't anticipate that this is going to be a bad result going there. I just want to know.
No, I understand.
If that point is true, that did not, that amendment, whatever the addendum, did not retract the 2% from the first contract, and other than what was specified in that addendum. Is that correct?
Well, we would submit that as a matter of law it did, because under principles of amendment, you strike out anything that's not consistent with the amendment. But you're right, they didn't
Have to be in writing? Don't you follow the statute of frauds? I mean, you change a contract, you can't,
Oh,
I mean, where are you going to get this from other than saying something outside is interpreting?
Absolutely,
Is there
absolutely.
anything in there that eliminates the 2% cap that was originally there?
Oh, well, first, the 2008 addendum very clearly was in writing, signed by both parties, so there's no question of that. And there's no requirement under the statute of frauds that every single provision be in the amended agreement. All it requires is that the amendment be signed. So there's not a statute of frauds problem with the 2008 amendment itself. The question that's posed is, what is the legal, what did the parties intend in 2008? What did they intend as to the years beyond 2013?
That is, intent, meaning, but when you're dealing with plain meaning of contracts, and under the law, when you do an amendment, it's pretty much understood, at least in this particular venue, that if it acts as an amendment acts as a substitute for the original contract, but only to the extent that it alters it. I think you agree with that. And you're saying this, in fact, does it. But the original contract may be abrogated in part with the rest of it remaining in fact. You do agree with that?
I think that's a possibility. I think,
I think
again,
I'm quoting that from some case or somewhere. Where did I get that from? I didn't make that up. That came from the black case.
well, see, the problem here is the parties didn't address the circumstance that actually eventuated, which is that they agreed to extend the relationship.
Well, I
beyond
totally agree. You
2013.
guys didn't sit down and talk about how this thing was going to work out. That's why you got this misunderstanding. But
That's
the
what-
point
that's
you
what
reach
the
here,
employers employ.
what you were doing then doesn't follow if what we got to do is deal with the law that is existing during that time.
And the law-
This is
the law, Your
Pennsylvania law, right?
The law, Your Honor, here is the UCC, and I think that's an important consideration, because as you know, the
When you say
UCC
UCC, you mean as adopted by the state of Pennsylvania, right?
Of course.
Yes.
So
I mean-
Pennsylvania has adopted the UCC and incorporated it into its
Yes.
statutes. And as you know, the UCC takes a rather pragmatic approach toward contract interpretation. I mean, the common law is, well, you look within the four corners to determine if there's no ambiguity, then you just look to the plain meaning, and to find the meaning, you open up Webster's, and that's the end of it. Well, the UCC takes a more pragmatic approach that focuses pretty intently on how the parties applied the terms of the contract. I mean, basically the point is that to figure out what the parties meant, you look at what they did. And I mean, this is stated very clearly in the official comments to UCC 2202, and I'll quote it. It says, "The course of actual performance by the parties is considered the best indication of what they intended the writing to mean."
Right, but you don't have any ambiguity that you've identified in the language, have you? I mean, you have at the bottom of Appendix 152 in the language of the addendum, Lindy will also be extending the current product supply agreement through September 1st, 2013. So there they referenced the umbrella product supply agreement, the agreement under which you're contending
The
the
agreement
2%
The
kicks
agreement as
back in.
modified by the 2000.
And they're saying they're extending it through September 1st, 2013. That's an end date. So what is there
Well,
to suggest that the product supply agreement that was extended through a firm end date in the addendum suddenly springs back to life? How do you get there?
I'm sorry, what springs back to life, Your Honor?
The 2% provision.
Yeah, we don't think that it does.
Okay, well then, how does the renewal provision spring back to life?
Because the renewal provision, unlike the 2% cap provision, was not changed by the addendum.
Well, but wasn't it? By the language saying that the current product supply agreement is extended through September 1st,
And that's
2013.
perfectly consistent with the
Well, you
automatic
look at
renewal
the-
provision operating as well.
Well, the renewal provision, though, provides for an automatic, 10-year?
Yeah, it's pegged to the initial term of the agreement. So
Unless it's terminated by notice. So it's 10 years or shorter, 12 months, if notice of intent to terminate is given. Well, that's different, isn't it?
Well, I don't think so, because, I mean, the parties can sit down and say, okay, we're not going to go by the automatic renewal provision, which would be 10 years. We're just going to extend it forward 5 years. But that doesn't mean that we're going to eliminate this requirement that notice be given 12 months before. That was still in effect, and as a practical matter, that's what happened. Nobody opted to terminate, and so the automatic renewal provision in this time applied because they didn't have a specific term that they agreed to, and that's pegged to the original term of the contract, which was 10 years. And I want to get back to your point about ambiguity. I think both the district court and
Let's cabinet to make sure we're talking Pennsylvania law. Pennsylvania law says where the express language and the course of conduct of performance cannot be reconcile, then you look to the express language to prevail over the course of performance. And so the question that we keep getting back, at least I don't know if it's a spring back or it's just there. I don't think anything's springing from here, at least in terms of what's being alleged on the other side. It's simply saying that in order to move from the original, you must explicitly state you are doing it. And there's nothing that I see here that say the 2% cap was explicitly removed in the addendum. That seems to be the heart of the issue in this case. When we're looking at how to figure out what express language, we're looking at it, we can look at everything all day long, what you did, but then the contract says this, and it may look reasonable. Oh, it's indicating all that, but we're stuck with this under Pennsylvania law because this is express language. And so if you don't have that express language in there that removes that cap of 2%, then the course of conduct does not come in, course of performance doesn't come into play. Are you following me on that?
Well, I disagree that the express language of the contract says that even after the addendum, the 2% applies.
That's not the question. No, it doesn't say that. What it does not say is even after the addendum, the 2% is gone. The question is, that's the express language we're looking for. Not, because it doesn't have to say you have 2%. The 1980 and 98 contract said it already. The question is, to take it away, did you say it's no longer there? So that's the express language we're looking for.
And Your Honor, that you can find that express language in the 2008 addendum, which says we're going to reset the prices. We're going to put in place a completely different cap. The problem here is that the parties didn't say anything.
Why for
whether in the 1998
Why for
agreement.
5 years?
I'm sorry?
Why do you put 5 years on it if it's doing that? Why does it have 5 years? What's this?
Because that's in the 2008 addendum.
Yes, that's the point. I'm asking if certainly the addendum did it for that term that's there. The question is, after the term ends, what does it do?
See, I think our point is that, I mean, as a legal matter, the implication is that because it's inconsistent, it goes to the wayside, and we're just having a disagreement about what the parties intended would happen afterwards.
Counsel, can I?
And that's not addressed by either
Can I ask you a
instrument.
question? So I think the district court thought, look, the agreement is silent on what's supposed to happen after 2013. There's no express language saying that the original caps spring back. There's no express language saying they're gone for good. There's silence. And the district court thought, I don't want to try to describe the district court's reasoning. I understood that at least your second order argument would be, look, if there's a gap, if there's no express language either way, then under the UCC as adopted by Pennsylvania, that's precisely when we look to a course of conduct. Because I think that it says specifically, it can fill a gap. A course of conduct can fill a contractual gap. So I thought that was sort of, your first argument is, look, it's clear under this kind of partial abrogation theory, it is actually clear that there's nothing to spring back. But I thought your kind of backup alternative argument is there's no express language either way, there is a gap. And then for 7 years, everybody acts like the 2% caps are gone, and that's how we fill the gap.
That's absolutely right, because the parties never expressly stated in the 2008 addendum what would happen afterwards. And so we do have a gap. And under the UCC, parties' course of performance can be used both to clarify as well as to supplement the terms of the agreement. And I think the district court was under the misapprehension that you had to first somehow find an ambiguity, that you couldn't just gap fill in this way. You had to find some sort of ambiguity. And that's just not the case under the UCC. And I point the court to the official code comments to 2202. And it says, pretty much in no uncertain terms, says this section definitely rejects the requirement that a condition precedent to the admissibility of the type of evidence specified in paragraph A, which includes course of performance, is an original determination by the court that the language used is ambiguous. So there's no requirement that you find an ambiguity. And the code says this is when you have a gap, course of performance is the ideal thing to fill that gap. Because again, the best way to figure out what the parties meant is to see what they actually did. And this case is even stronger than the cases that we cite in our brief. And there were like, 2 instances of performance or 3 instances of performance, and the court said, okay, well, that's enough to establish a course of performance that's consistent with your theory. And in this case, we've got literally dozens of instances of performance. We've got notices of price increases that were more than 2%. In fact, for every year, for 7 years, for every single gas, hydrogen, helium, nitrogen, and argon, the price increases were greater than 2%. And believe me, the current opposing party was not the party that was a signatory to either the original agreement or the addendum. They came in after the fact. But in 2013, Marcy Gagliac, which did sign the addendum, they were still there. And believe me, it was their understanding that the 2% cap would come back into effect, the first thing that they would say when they got that notice is, wait a second, we didn't agree to that. We agreed that the 2% cap would come back into effect. And they didn't say that. And they didn't say that time and time again. I mean, dozens of times there were price increases greater than 2%, and they said nothing. And, so it is the dog that didn't bark. It is their silence that is most telling about what the parties intended in 2008.
So what is the impact of SBA on this, that case there? Where you're going, the question is, does Pennsylvania law preclude that type of a holding?
The SBA was not a UCC case.
I understand that, but the principles nonetheless in terms of silence are there.
Well, the holding of you.
Because you're talking about a contract type.
Well, the principal holding of SBA was, and I see my time is out, but I don't want to run too much into my rebuttal time. But the main point of SBA was that silence alone can't create an ambiguity, and then therefore you can't have a course of performance. But under the UCC, you don't need ambiguity to establish course of performance. You can use silence. I mean, you can fill a gap with course of performance. And that's how the UCC differs from ordinary Pennsylvania law.
UCC is adopted by Pennsylvania, and Pennsylvania law, you don't need ambiguity. In other words,
that's correct.
You can have an express contract that says something and still use course of performance. That's your.
You can't use it to contradict the contract.
But the point being is that the plain language can tell you something in a contract, but course of performance under this circumstance can prevail.
Well,
because you said we didn't need ambiguity.
Well, there's 2 things. I mean, SBA said silence can't create an ambiguity. And we're not saying that the course of performance has somehow altered the plain language of the agreement. We're saying there was a gap, and the course of performance filled that gap and explained what the parties intended when they entered into this.
And I'll let you address it when you come back, but the question then, at least from my perspective, is how do you create a gap if the 2% was never removed? What is the gap? So ponder that on your return.
I'll address that when I stand up again. Thank you.
Why don't we hear from the other side? You have some moments for rebuttal, so we'll come back to you later, Mr. Rainsbury. So we'll hear now from Mr. Johnson.
Yes, good morning. May it please the court. My name is Harold E. Johnson. I represent Bristol Metals, LLC, the appellee and cross-appellant in the case. Judge Wynn, I think you got it exactly right with your focus on the plain meaning of the written contracts. That is the touchstone for contract interpretation, not only in Pennsylvania, but generally around the country. And in this particular case, we have not 1, but 2 written instruments, each of which include price caps. And those price caps were specifically bargained for. When you look at the original product agreement, the price cap was added by a typewritten codicil to the form agreement that was supplied by the seller at the time. So clearly the price caps are an important part of the agreement from the purchaser's perspective, given that they're entering into a long-term exclusive supply agreement, they need to have some form of price control. Well, the result that Messer argues for is that even though you've got two written instruments that explicitly require price caps and indicate the party's intent to have price caps in place, that somehow you can discern an intent to completely abandon price caps when the addendum expires in 2013. That makes no sense.
What's the difference between a gap and silence?
Well, Your Honor, I think the district court got this exactly right in relying on SBA Towers when it noted that silence cannot create grounds for a party to use course of performance or to find an ambiguity in a contract. And the SBA court noted, and the district court, Judge Novak, after summarizing the SBA decision, said silence does not do that much work. A party cannot use silence to come in and argue for a position that the parties simply didn't address in the contract. Parties might agree to omit certain terms from a contract for all kinds of reasons. You can't presume from that silence that the court should be called upon to fill, whether you call it silence or a gap.
So so the Pennsylvania statute on this says that you can look at course of conduct to give particular meaning to specific terms of the agreement, but also to supplement the terms of the agreement. That just sounds to me like what they're saying is if the terms of the agreement don't actually address something, and there's a gap or silence, whatever you want to call it, you can look to course of performance to supplement.
And Your Honor,
Doesn't that mean to sort of fill a gap?
well, I would respond in two ways. First of all, course of performance in the terms of the UCC can only be used to do that if it can be read consistently with the express terms of the contract.
Right, and so where is the express term that says after 2013, we're going back to the 2% price caps? I agree that if the addendum said that for these 5 years, we're going to the 8 and 9% price caps, and then we're going back to 2%, there'd be no course of performance argument here. There might be a waiver argument, but there wouldn't be a course of performance argument. But I don't see the express terms that foreclose that reading.
It's not expressed in the 2008 addendum, nor is the corollary expressed, which is,
Right,
I think,
that's the
Judge Wynn's
gap.
point. But, Your Honor, I think the fundamental point is that you have to look to the party's intent. And under the UCC,
Where am I supposed, if it doesn't say one way or the other expressly what happens after 2013, and I need to figure out the intent, isn't that exactly when I'm supposed to look at the course of performance?
no, ma'am, because the express language that the parties use in both agreements includes a price cap. And I would submit at the very least, the 8% price cap in the 2013 addendum would have to carry forward. But I want to make another point about the addendum, Your Honor. Parties can modify a contract temporarily, and that's what this addendum did.
But what about
Lessor-
but counsel, Mr. Johnson, what about the fact that the addendum provides a hard end date? That's the problem that I'm having with the argument that I'm hearing. The contract says the addendum at 152 says the current product supply agreement will be extended through September 1st, 2013.
Yes, ma'am.
And so what about that is unclear? It's extended through September 2013. Isn't the only reasonable reading that it won't be in effect afterward unless something else is done?
I agree completely, and that
Okay.
was my point. This addendum was temporary. It had a finite lifespan. And so to the extent it altered the terms of the original product agreement, it only did so for that 5-year period, a discrete period. Then the question becomes, are the parties operating at will?
What Judge Keenan just said, if I'm understanding correctly, she's saying the contract ended on 9/13 or 9/1/13, and that would seem to indicate that what happens from that date is an at-will type contract didn't exist.
And we made
So
that,
then how, I'm trying to understand how that's going to fit in your argument.
well, we made that argument. Messer can't have it both ways, where they get to say, you're bound to a long-term exclusive 10-year renewal under the original product agreement, but we get to jettison the price controls that you have in that agreement.
Can I ask you a question about this? I feel like this is my role for the day. So the district court held this agreement is up for termination in 2023, And you didn't cross-appeal that, did you? Your cross-appeal seems to be limited to the damages question.
We cross-appealed on the damages question because the issue,
So we're stuck. We have to assume, since no one appealed it, this agreement ends in 2023, or at least it's up for termination in 2023.
well, Your Honor, we did not appeal that issue because we were the prevailing party.
I understand, but you could,
Yeah.
that's what cross-appeals.
But I do think I don't believe this court is stuck. I think if the court were inclined to accept Messer's argument that after 2013, there is no price cap in place, it would also be appropriate to remand for the district court to consider what that means for the renewal period. Because as Judge Keenan has noted, this 5-year extension under the addendum is absolutely contrary to the renewal provision in the product agreement. And so if the price caps that are different in the second agreement mean that you no longer have the price caps in the first agreement, then the term provision in the second agreement means you no longer have this renewal and term provision in the first agreement as well. So I think...
So without reaching the question ourselves, you think I just want to make sure, it's hard for me to keep the argument straight, but that if we thought the 2% caps had been abrogated, we should remand and let the district court figure out how that affects the rest of the case.
It's a question that we presented to the district court and a position we took. We asked for declaratory relief as an alternative.
No, I know you raised it in the district court, yeah.
Yes, and so I do think that's an issue that can be addressed by the district court on remand as to what the impact would be in that situation, should the court find that way. The other, Judge Harris, you raised a question earlier about the gap, and doesn't the UCC allow for course of performance to supplement the terms of a contract? Generally, that provision is in the UCC. However, if you look at the specific provisions governing the sale of goods, and specifically Section 2209 of Title 13 of the Pennsylvania Code, that's where you get a separate set of rules for contracts for the sale of goods that require a modification to be in writing. And so in addition to 1303, which says that the express terms will prevail over a course of performance where they're irreconcilable, which I would submit we have here, Section 2209 requires for contracts for the sale of goods worth more than $500, you have to comply with the statute of frauds in order to have any sort of modification of the terms.
But I thought that was a whole separate argument that was made below. The district court rejected it. It's not on appeal. That quite apart from the contract, forget the contract, just anything the contract says now is changed by the course of performance. And the district court said, nope, you haven't complied with the statute of frauds, and no one is appealing that. So that's not really, there's not a statute of frauds problem here because everything is in writing, and we're just trying to figure out what the writing means.
There is no writing that says we will not have price caps moving forward. And that would be a modification of both the 1998 product agreement and the 2008 addendum to hold that Messer can just charge whatever prices they wish until the ultimate expiration in 2023. That would be a modification of the party's written agreement.
Can I just ask you, sorry, on a slightly different question about the course of performance? So I know the UCC says that you pay sort of special attention to a course of performance that's contrary to someone's economic interests, right? Like obviously, the theory would be obviously if you thought the 2% caps controlled, you would have said something because it would have been so advantageous for you to hold them to those caps. Do you have an account for why that didn't happen?
We don't. There's no evidence in the record of that, and that has to do, we're several parties removed from the original contracting parties. But I think, Your Honor, the evidence that is in the record suggests the following. When Bristol Metals assumed this contract in 2017, they immediately tried to terminate it. And they were told by Messer, oh no, the 1998 product agreement is still in place and it was renewed in 2013. In December of 2013, not when this addendum expired in September, but later on that year, when a new hydrogen tank was replaced at the facility. Messer said that triggered the renewal provision in the product agreement. So Bristol Metals, thinking, okay, we're stuck with this for another 6 years, they went along with it, and I think what caused them to take a deeper look, Your Honor, is that between 2017 and 2020, the pricing for helium spiked under this contract, the charges they were getting from Messer, by 60%. It went from, I think it's around 31 and 48 cents per unit to 49 and 50 cents per unit. So practically speaking, I think that's when Bristol Metals took a look at this and said, this is crazy. We're stuck to this long-term agreement with no price protection. How can that be? And that led to their ultimate decision to pursue this, this matter. But certainly there are all sorts of reasons why parties may waive rights and you know, pay an elevated invoice over time, whether it's economic efficiency, to keep their supply chain intact, to avoid litigation costs. I would note that the Municipal Authority of Westmoreland County case that was relied upon by the court and is cited throughout both sets of briefs, that involved a waiver of over 9 years, where the party did not exercise its contractual rights for 9 years. And then when it came back under new ownership, similar to what we have here, and said, no, we want to tack in, it had to do with refunds or post-production costs, rather, for gasoline production. And so it changed the pricing. When they said they wanted to exercise that right, the court in Municipal Authority of Westmoreland County noted, well, you may have waived it retroactively. That does not work, and that course of performance does not work as a modification of the contract moving forward. So again, that's where I think, even with a gap, Your Honor, Section 2209 requires that there be some writing to fill that gap. Otherwise, you revert back to the party's expressed intent in the words that they used in the written agreements. So you've got the 2% price cap under the product agreement, a finite 5-year extension with an 8% cap under the 2008 addendum. One of those has to apply. If I may, Your Honor, I'll move on to our cross appeal as to damages. And here, we think the district court erred because it held that Bristol Metals waived the right to bring a cause of action for inflated invoicing based on the 2% price cap, because it did not, even though it did not pay any invoices at the inflated prices from the start of 2020 forward. And so we would submit that Bristol Metals is entitled to damages from the time it revoked its waiver on January 24th, 2020. There's several reasons for this. First, the court's ruling runs afoul of the applicable law governing installment contracts. Under an installment contract in Pennsylvania and elsewhere, every delivery or invoice is a separate transaction that gives rise to a separate cause of action. It follows that Brismet's waiver applied on an invoice-by-invoice basis, not on an annualized or prospective basis. That's consistent with the product agreement itself, which has payment terms of net 10 days and specifically gives Bristol Metals the ability to challenge an invoice or delivery within 10 days after receipt. Secondly, the court's ruling conflates the issues of waiver and modification. And this again goes back to the municipal authority case that I just cited. The court effectively found that Bristol Metals waived its right to contest all invoices for 2020 before it had even paid any of them, and after it received the first ones, actually before it received those. That actually is not a waiver, Your Honors, but a modification of the contract. It is saying we are going to change the pricing term prospectively for at least 1 year and beyond, because the price increases are cumulative. That's a modification, not a waiver, and the municipal authority case makes that clear. It refers to a waiver as prospective and permanent, or excuse me, a modification as prospective and permanent, whereas a waiver can be temporary and is generally retroactive or retrospective. Waiver, as the court and municipal authority noted, is most often used as an affirmative defense to a breach of contract cause of action.
So would you characterize the 1998 agreement as an installment contract, and how that would affect in terms of how often the 2% cap recurs in the invoices that it receives?
Yes, sir. It is an installment contract as defined under the UCC, because it calls for separate deliveries over time and different deliveries and invoices. And I think it's interesting, in its opening briefs in the court below, Messer acknowledged that until Bristol Metals receives an invoice, it doesn't even have a cause of action for breach of contract. And this is in the judicial appendix at pages 104, 105, and we quoted it in our briefs in this court, where Messer understood that in an installment contract context, it's the receipt and payment of the invoice that gives rise to a claim for damages. Messer's announcement that it's going to raise its prices may be a statement that it intends to breach its contract, but until Bristol Metals makes a payment under protest, it doesn't have the damages to sustain a breach of contract action. Messer made that argument in contesting our right to bring a declaratory judgment action.
I feel like maybe there's something I'm not understanding, and you can clarify it for me. So assuming the 2% price caps are in effect, the breach happens when the costs go up by more than 2%, right? When the prices are in fact escalated beyond 2%. And so if that happened before the waiver was retracted, even if your cause of action for that breach doesn't accrue until you pay and have now have damages, those seem like two different things to me. The time of the breach, which would be when the costs go up by more than 2%, and the time you pay it and accrue your cause of action. But are those actually the same thing? Is that what you're saying?
Well, I think it goes back to the point that waiver is an affirmative defense to a cause of action for breach of contract. We could only waive our right to bring a cause of action for the inflated charges on any given invoice. Had we received this notification, and I see my time is up, if I may attempt to answer Judge Harris's question. Had we received this notification and then run to the courthouse to file a lawsuit, we wouldn't have had a claim yet.
But you didn't have to, I think what the district court thought was perhaps that you didn't have to run to the courthouse, you had to object.
That is what the district court thought, but that conflates what I've called the market check mechanism in the contract, where we could get a competing bid within 15 days with the price cap, which operates independently. And so I think any invoice that has improper pricing beyond the 2% price cap is actionable once we pay it.
All right, Mr. Johnson, you reserved some time for rebuttal, it looks like to me, which is what I'm seeing. Is that correct?
Yes, sir.
All right, we'll hear back from you in a
Yes,
second.
sir.
Let's hear from Mr. Rainsborough.
Okay, if I can start briefly by responding to the damages point. I think what the court needs to focus on is, well, what is the alleged breach here? The alleged breach is increasing the price more than 2%. When did that occur? Well, it last occurred on January 1st of 2020. But the district court said that Brisbane has waived any objection to price increases that occurred before they retracted their waiver, which was January 24th, 24 days later. And so they don't have a claim at all. I mean, their suggestion is that every time the goods are invoiced, that means that there's been a price increase. And that doesn't follow. That doesn't make any sense. The price increase was on January 1st, and that was before the retraction of waiver. And I want to respond briefly to their argument that somehow they were stuck in this contract and that Messer could raise the price whatever it wanted, you know, helium 50%, 80%, 90%, whatever. Well, the reality is the contract has another protective mechanism, and rather than have a specific percentage cap, it has sort of a I cut, you choose arrangement. It says that we'll propose a price increase, and you've got 15 days, and you can either come forward with a better deal, or you can accept that price increase. So if they could have come forward with a better deal for helium, then they had every opportunity to, and that would have gotten them out of the requirements contract. They never found a better deal, and so they never took advantage of that provision. And finally, I just want to go back to the 2008 addendum. I think there's probably a reasonable disagreement about, you know, what the silence means, whether the silence means that there's no price escalation cap after 2013, whether it means that you go back to the original 2%, or maybe that you just, you know, you keep on with the 8% that was in place in 2013. But the problem is nothing in the 2008 addendum addresses that. And so the parties were silent on that. And that is exactly the type of circumstance that under the UCC, you look to how the parties actually, in practice, apply that agreement. And course of performance is particularly important where the party who's now claiming a different interpretation of the contract actually performed it in a way that's in accordance with a less favorable provision. It's like an admission against interest. So
Thank you, Mr. Rainsborough.
thank you, Your Honor.
Mr. Johnson, you have just a brief rebuttal.
Yes, Your Honor, thank you. And I'll return to Judge Harris's line of questioning when I was last before you. The distinction between a breach of the price cap by notifying Bristol Metals that Messer was going to increase its prices and the invoice by invoice breach that I've advocated for is again where the line between waiver and modification gets blurred. And that's what the municipal authority case, I think, stands for. Waiver can only apply when you have a cause of action, when your rights have been adversely impacted by the breach. And so a statement that, hey, we're going to raise our prices in breach of the contract does not give rise to a cause of action until that damage is actually occurs and the cause of action accrues. That's when the statute of limitations begins to run. And so I think that's the distinction there. With regards to Mr. Rainberry's final point as to silence creating ambiguity, I think that's in direct contravention of the SBA case. And I would also note that SBA was not a contract for the sale of goods, but it was a commercial lease, so it is technically governed by the UCC. Your Honors, if you have any further questions, I'd be happy to address them.
Judge? Thank you very much. Thank both of you. As you heard me say previously, we have suspended the practice of coming down to shake your hands. I do continue to recognize that is a tradition and that will remain in this court, something that we reinstated, but for now, as indicated, we believe the risk exceeds the benefits, and we don't want to give you anything to take back home to your loved ones and those that you're with, and we don't want you to give us anything. So we think this position is quite well where it is, but we're glad to have you here, and thank you for your wonderful arguments. So we're going to stand in recess for 5 minutes, and then we'll come back and hear the final case for the day.
This honorable court will take a brief recess. Court of Appeals for the Fourth Circuit.
Please be seated. Let's go to the last case for today. That case would be Techman versus Reliance Standard Life, and we are prepared to hear arguments from the appellate's lawyer, Mr. Backrack. Backrack. No one gives me credit for being able to pronounce names the first time, but I tried to do it the second time right.
Your Honor. Good morning. May it please the court. Joshua Backrack. I represent the defendant appellant in this case. This lawsuit involves a claim for disability benefits under an ERISA plan. The district court made a number of mistakes when it entered judgment in favor of Ms. Techman, including the way in which the court addressed the issues that were put forth. The court scheduling order called for summary judgment motions. The parties filed summary judgment motions, and there was even a hearing, and the court only referred to summary judgment under Rule 56. But then the district court decided the case under Rule 52, and that matters for a few reasons. One, it matters to the standard of review applied by this court, whether it looks to clear error by the district court or it conducts its own de novo review of the claim decision.
Before we went to 52, didn't the district court say I'm denying the summary judgment motion?
The court said I'm denying the summary judgment motions and deciding the case under Rule 52.
Okay, so your contention is should have proceeded as a summary judgment, or there's some de novo review or something?
Well, the Supreme Court has said that the parties can decide, or the ones who are to decide, how to present an issue to the court. And the court agreed to hear the case under a joint scheduling order under Rule 56. So there's no basis. And if you look at the law of this circuit,
Can I ask,
there was
just
no.
to follow up, counsel? So the district court denied summary judgment, and it sounds from the order, he said, based on the state of the record. So I assume because he thought there were disputed issues of fact that needed to be resolved. So what is it, if there are disputed issues of fact precluding summary judgment and there's no right to a jury trial in these cases, what is it the district court's supposed to do other than have a Rule 52 bench trial?
The same thing that every district court has done in this circuit, Your Honor. Courts in other circuits have said that Rule 56 is only the means to get the issue before the court.
This is like the fake summary judgment thing. They should call it summary judgment, but the district court should make findings of fact.
Correct. Well, it shouldn't make findings of fact necessarily.
Well, who's going to resolve the fact disputes then?
Well, Your Honor, all I can say is that this is the way this court has done it. This is the way.
What is the way? I mean, you actually haven't answered the question.
Rule 56.
So it's Rule 56. There are disputed issues of fact. So under the vehicle of summary judgment, the district court resolves the disputes.
The district court resolves the question of whether the decision is correct in the first instance. But let's look at what this court has said. In Johnson versus...
It is a genuine question. I don't understand your position. So if there are disputes of fact, there's no right to a jury trial, and you don't think there should be a Rule 52 bench trial, how do those disputes get resolved?
Rule 56 puts the issue before the court, and I'll explain what this court has said.
Can you, don't tell me what the court has said, just answer. So the district court should resolve the factual findings, but call it summary judgment, and then we should...
Yes, Your Honor.
Why would we do that?
Because that's the way this has been done. In
Why?
the Johnson...
That doesn't make any sense.
Why has it been
Because
done?
the issue is just the vehicle or the conduit to get the issue.
Well, who says it has to be done that way when you have you know what hangs this up is what we know to be summary judgment. We know you don't give summary judgment. We hear it all the time if there's a disputed issue of fact. You're saying this is a special vehicle that's used in this area of the law for which the court has carved out something different. Who carved it out?
This court has, Your Honor. Last year in Shoup versus Hartford Life, this court held, and that's 19 F 4th 697, this court stated on de novo review, our job is to make our own independent determination of whether Shoup was entitled to the LTD benefits. In Johnson versus American United Life.
I see. So this is like this business about its de novo review if the administrator didn't have discretion, right? That's what you're talking about, the cases that say that? But that's a different question.
It's not, Your Honor, because now I'll go to the case that it relied on, which is Johnson versus American United Life. In an appeal under ERISA, We review a district court's decision de novo, applying the same standards governing the district court's review of the plan administrator's decision.
So you read that case to say that when there are disputed issues of fact, district court should decide them and then pretend that it's doing summary judgment, because I don't see that in that case.
Your Honor, in every disability case, there are issues of fact.
That is not true. Some of them turn on the language, the contract language, and can be resolved as a matter of law.
Very few, but in most
Okay,
disability
but
cases.
some can.
Some, but not all. And in the
You
Shoup
said
case.
all, and I think it matters that we're clear about this because there are a lot of courts who have explained that there is a limited role for summary judgment in these cases. When there are no disputed issues of fact, courts should decide them on summary judgment. When there are disputed issues of fact, of course, you're going to need a bench trial under Rule 52. And I know that there are one or two circuits that have said, you know what, let's just call it all summary judgment. I will, however, note that even in those courts, they do review those fact findings by district courts for clear error, not de novo. So I don't really know why it matters so much to you what we call this.
Well, Judge Harris, this court has never applied Rule 52. This court has never addressed a Rule 52 on an ERISA disability case under abuse of discretion or under de novo
So your
review.
position, as I understand it, is there can be no Rule 52 bench trials in ERISA cases. It all has to come under summary judgment, including when there are disputes of fact. That is your position.
Yes, and in the Shoup case, there were disputed issues of fact. There were opinions on both sides, and counsel knows it's because he handled that case. And what we're saying here is that the standard by which this court decides this case, reviews this case, shouldn't depend on a judge saying, I'm going to choose Rule 56 over Rule 52 or vice versa, and it shouldn't depend on who won in the district court.
It depends on
below.
whether the district court made factual findings. If the district court made factual findings, we review those findings for clear error, whether he called it Rule 56 or Rule 52.
And the district court in the Shoup case made factual findings, and the Court of Appeals in the Shoup case made findings of fact as well. There is not one.
Could I
and-
ask you a question?
Yes, Your Honor.
I'm worried that you're making an issue where there might not be one. You agreed in the district court that the administrative record was the sole record
Correct.
in the case. Okay, so why couldn't the district court have proceeded under Rule 52? And once it did, you didn't lodge an objection, did you?
How could I? Because there was a hearing, and it was mentioned at the hearing itself that we were applying Rule 56.
Right, but
We never had a
afterward,
chance.
did you bring it up to the district court?
It was never an issue, Your Honor, because, well, I will say that counsel mentioned after filing Rule 56, the plaintiff then said, well, maybe the court should use Rule 52. But the court then at the hearing never addressed the issue, never said, should I do 56 or 52? So we never had that opportunity.
Okay,
But the point, Judge
what were
Keenan-
you denied? What were you denied as a result of the court making factual findings under Rule 52?
Two things, Your Honor. First, there were admissions because they failed to follow the rules. They did not respond to our statement of material facts. That's one. Secondly,
Right,
it
but
affects.
the district court didn't want to, the district court exercised its discretion, did it not, in that regard?
It didn't say so.
Well,
I
isn't that the only fair inference from the record?
I don't think that's.
That it went on to consider the facts?
I don't think that can be an inference, Your Honor. I think it has to address it. But I'd like to just, I'd like to just
Before you
point.
do so, tell me, did you cite that Shoup case in your brief?
Which case, Your Honor?
Shoup case.
I don't recall that.
You certainly argued it today. I'm trying to determine where we are. You did bring up the Johnson case.
Oh, I'm sorry. The Shoup case was part of our supplemental authority that we submitted to the court last December, I think it was, after it was decided, because the case had been fully briefed.
That was in your 28J motion, you brought it up.
We brought up.
Let me ask you about the
28J.
Johnson case, because you tie in the Johnson case as the basis for it. And Johnson, I'm trying to understand how that helps you, because that really was, we were reviewing the grant of a summary judgment. That's different than what we have here.
But that's the point, Your Honor, is this court has always ruled under de novo review based on summary judgment, even when there are conflicting facts. And why that matters, Judge Keenan, you'd ask.
When we're reviewing the grant of a summary judgment, what we're looking for is to determine whether there were any disputed issues of fact. We say yes, what do we do then? Send it back, right?
No, Your Honor.
So you're saying that if in these cases where there is a grant of summary judgment and on review, we then review it to determine there's disputed issues, we say there are disputed issues, you then say this court resolves the dispute?
That's what this court stated in Shoup, which is a published decision on de novo review. Our job is to make our own
Where have we said
independent
it anywhere
determination.
else in any other area of the law? I have never seen that, and maybe Shoup is something I better reread.
Yeah, say again what Shute said, that under de novo
Under
review.
on de novo review, our job is to make our own independent determination of whether Shoup was entitled to LTV
No, but that's a
benefits.
different question. That is about whether we give any deference to the plan administrator or whether the courts for themselves are supposed to figure out whether the benefits were properly denied. I just really don't believe you have a case that says the appellate court will make findings of fact and weigh credibility.
I do, Your Honor, and that's the
Okay.
Johnson case again. Johnson says, in an appeal under ERISA, we review a district court's decision de novo, employing the same standards governing the district court's review of the plan
You think
administrator's
that means
decision.
we decide facts? We're going to judge the credibility of the plan administrator and the
that's-
plaintiff right here.
That's the important thing, Your Honor. This is a paper record. There are no witnesses. So there's no credibility of a witness that needs to be determined. There's just the same paper record in this court as there was in the other court. I'd like to move on. I think, Your Honors, I implore you to look at those cases. They say what they say, and they require this court to take a look at it de novo, not giving deference to what the district court stated. Now, let's look at what the district court here did, because that also was mistaken.
And that is important for you to do that. I want you to do it. But if you're listening to your court, how are you even going to get there if you don't work on convincing us that when a matter is resolved at summary judgment at district court and it comes to here and we find a disputed issue of fact, that this court then undertakes a fact-finding role itself as a matter of course in these cases? We may have, because the record is so clear as to what the outcome, there have been cases we've done that, but that's not, from what I can determine, something that's been happening. Now, let me say this. You can perceive on as you please, but I'm telling you right now, that may not be a good course of action if you are listening to a court that's going the other way. And maybe we will change our mind in the back, but it's your argument.
Your Honor, I can only say this. This in Shoup, the district court ruled against the plaintiff based on the facts. This court conducted its own de novo review of the facts and disagreed and said that the plaintiff was disabled under de novo review, its own de novo review of those facts. Again, courts in other jurisdictions, a minority of jurisdictions, say we review under Rule 52, that is a minority. Most say, again, the First Circuit has said, this is just a conduit to get the issue before the court. The Ninth Circuit, in fact, has said the exact same thing, that summary judgment, there's a split, even in the Ninth Circuit, which the district court cited to. There is not one case that has decided such an issue. So I am going to move on because it's important to see how the district court made mistakes.
What is the cite on the Shoup case there?
The Shoup case is 19F,
I just want to be,
19F 4th, 697, and I would refer you to page 706 of the decision. And I'd like to move on again because the district court's decision is...
You may do so.
I'm sorry?
You may do so.
Oh, thank you, Your Honor. I apologize for interrupting. So the district court said, one of the big issues here is the court said that we overplay the issue of the lack of objective proof. That's not the case, because in the Gallagher case, the Gallagher court said that a claimant must provide objectively satisfactory proof of a disability. And in this case, we have our own Dr. Jaffe.
Counsel, I don't understand your argument under Gallagher. In Gallagher, the question was whether the proof has to be satisfactory to the plan administrator. Do we view it from that perspective, or whether it has to be just objectively satisfactory proof? There is nothing in Gallagher about how to weigh sort of subjective symptoms like pain versus objective medical proof. Gallagher is about something entirely different.
I respectfully disagree.
I bet you do.
And I argued that case 10 years ago to this court. That was an issue. And I would also point out, when you're looking at the Shoup case on how to review this case, I would ask you also to look at the language in that same case on this very issue. When they're talking about the burden of proof, the court stated that not only on de novo review how the court's to do it, but then talks about the burden. And it says, we look at the evidence before the plan. The burden of proving disability is on the employee, and he must do so via objectively satisfactory proof.
Right, meaning it has to be objectively satisfactory. You don't run it through the perspective of the plan administrator, but you think Gallagher says something about how we compare subjectively experienced symptoms versus other forms of medical evidence. That's what you think Gallagher stands for.
It says that you have to provide. Shoup says it. Shoup directly says it. I know I'm in my rebuttal time, but I think I need to finish this. Because if you look at the evidence in this case, her own brain injury doctor said that her symptoms are embellished. Every test, MRI, CT scans, cognitive tests, vestibular tests, which are what she's complaining of, are all negative or normal. And her own doctor, who she relies on, Dr. Parker, describes her symptoms as unusual and unique. He's never seen a case like this. We have 4 doctors who we retain who says this is not supported. So that's why you have to, we're not saying disregard subjective, but there has to be some objective if it's available. And in this case, there is. It's the vestibular testing, but it comes out negative. And
You seem to be saying, though, counsel, that there needs to be objective, an objective diagnosis
No, Your
as
Honor.
opposed to evidence of disability.
no, Your Honor. It's quite the opposite.
Well, here the trial court, the district court clearly placed more weight on the evidence. I mean, Judge Trenger was very careful. He went through all the doctors, and he felt that your doctors were not as persuasive as Dr. Parker and the other ones. Now, certainly a couple of the doctors for the plaintiff did have some questions about her symptoms, but the court was entitled to consider the evidence as a whole and determine on the facts or what the facts were. And so I don't understand how you can say that the district court was, its factual findings were clearly erroneous.
Well, we're not saying that, Your Honor. We're saying that you have to make an independent review
Well,
of it.
I know you're
But
saying
moving
that, but
beyond
I don't
that,
think.
But
yeah,
moving beyond that, Your Honor,
I don't think you're going to get anywhere with
well,
that.
then unfortunately, that's going to have to be an en banc issue because the law of this circuit's clear on that. But beyond that, Your Honor, Dr. Parker, who's the doctor she relied on, said that she's disabled. He's the one who said her symptoms are unique and unusual.
Yeah, but
and he's a family practice doctor.
But
You then
Dr.
have doctors.
Parker, all the way through, he talks about her post-concussion syndrome, severe hyperacusis, and magnified sounds become incapacitating. He said that she cannot tolerate working conditions due to the severity of the hyperacusis.
And
so
he's
Dr.
a
Parker,
family practice doctor, Your Honor.
Well-
She was sent by her own, he referred her to Dr. Jaffe, the specialist. And Dr. Jaffe's the one who said she's embellished and all the testing's negative, including for the vestibulopathy, which is the dizziness that she's
Dr.
claiming.
Jaffe said there was no clear cause for her symptoms in the imaging evaluations, okay? He thought her symptoms were embellished, but that's part of her, part of his report, but he also said there was no clear cause for her symptoms. So it's not that he was saying she was faking it. He was just saying he doesn't see objective evidence of central or peripheral vestibulopathy, right?
Your Honor, we're not talking about fibromyalgia where there's no dipstick, where there's no blood test. We're talking about vestibulopathy where there is testing for it, and it didn't support the claim. And then he says there's embellishment. He's the expert, not Dr. Parker and not Dr. Cintron. I know I'm eating into my time. I'd like to save some for rebuttal, and I can address this more then, Your Honor. Thank you.
You may do so. We'll hear from Mr. Cantor for the appellee.
Thank you, Your Honor. Glenn Cantor for the appellee, Anita Techman. Not the case I was thinking I'd be arguing this morning, Your Honor. First, I suppose I should discuss the Shoup case where I was counsel. And I think the court needs to understand what happened in Shoup. Shoup was filed in California.
Tell us about the law as it is in Shoup. And I looked through the Shoup case. First of all, the court does go through the summary judgment analysis. It points to all of the typical language and indicates the standard of review is to determine whether there is an issue of fact. But then the court pivots and then talks about a Supreme Court case that says that these cases are de novo. And there does seem to be a de novo review of the record by the court in which they then conclude. Typically, that occurs upon review of a summary judgment is where the facts are essentially undisputed. I mean, that's, you know, that's what gets it to a question of law and a de novo review. But if there are factual disputes to be resolved, that doesn't typically happen at this court. So did the court in Shoup effectively conduct a factual determination as opposed to a purely de novo review based on the law of facts that were in place? Now, there were stipulations in this case, and I don't know the extent of which those stipulations listed those facts and disputed, but address that. I think that's, I think you got to get it, somehow we got to get off of this in terms of this summary judgment versus Rule 52, because we're not following it too well that we're going to be doing factual reviews up here on any kind of cases. We don't do that if we can help it unless it's clear. So address that from the Shoup's perspective.
Well, the way I would address that, Your Honor, is, as I said, the case was filed in California. It was transferred here. Judge Claude Hilton said, I want motions for summary judgment. They were filed. He ruled in the favor of the insurance company. We appealed, brought it to this court, and this court said he was wrong. They did a de novo review of his findings because it was a summary judgment. What I would say to this court, and I would read from the decision in Horton v. Life Insurance Company of North America.
The de novo review of his findings was the review to determine if there were issues of fact, or was it to assess credibility and assess which side should prevail?
I think the court decided that based on the facts before it, the record before it, and it's a closed record, that he was clearly wrong. But they did not say they were looking for clear error. They said, because this is summary judgment, we are looking at what Judge Hilton did de novo. Mr. Bacharach is arguing that this court should look at what Judge Trenga did de novo, and we would argue no, that he ruled under Rule 52. There are different standards. But if I could just briefly say that in the Horton case where Mr. Bacharach was opposing counsel, there's a divide among the circuit courts of appeal and a void in the Fourth Circuit as to whether FRCP 56 is necessarily the appropriate mechanism to resolve an ERISA claim for denial of benefits. The point I would make to this court is, we talked about a gap in the last case and a void. End the void. This court, as all the circuits courts should do after 30 years of these cases, is say the appropriate mechanism for bringing a case where there are factual disputes to the district court is a Rule 52 motion, because the court is then making factual findings. Yes, there's an agreement that this is the record. These are the documents. But, of course, the parties don't agree what those documents say. The court has to make credibility determinations about the doctors. It has to make medical determinations as to which is more compelling. But the circuit courts across the country, and I guess the Supreme Court, has not made a determinative statement that the appropriate mechanism is either 52 or 56. I've been doing this for 30 years, and I've gotten different rulings from different courts as how they want it brought. Some want it 56, some want it 52. I would think this court should take the opportunity to clearly tell the district courts, this is how we need this done. For a policy point of view.
Well, the big difference of what it means, I mean, you really don't have to have the confusion if you're simply saying you can go summary judgment just like you do in any other case, but if there are issues of fact, then the trial judge would then determine them on the 52, what it would be. The question comes is what happens when it comes up here? That's your problem. You want, there needs to be 2 de novo reviews of something here. And Supreme Court language in Firestone says that challenge of benefits is reviewed under the de novo standard. And it says unless the plan gives administrative authority to determine eligibility. But I'm not sure what the Supreme Court meant in that, but it doesn't seem to me they meant there should be 2 trials.
No, Your Honor, I think in the Supreme Court, they were starting off with a determination of how a district court should review a plan administrator's decision, whether it was de novo by the district court or to give abuse of discretion to the fact finder. The Supreme Court in the Firestone case said that absent language giving discretion to the plan administrator, the court would review it de novo. That's completely different than how a circuit court will review the factual findings of a of a district court. We are here, and this court should be looking at Judge Schrenga's decisions for clear error. I would argue that the last standard waived any complaints that this was a Rule 52. Mr. Carter, the trial counsel for plaintiff, made it known in his pleadings that he thought it should be 52. The defense, in their summary judgment reply, said, well, it's not a strict 52. Well, if it's not a strict 52, what it is a Rule 52 by a different name. And the court, and he made the same argument in oral argument, and the court in the transcript said, well, I'm really going to be finding facts. He then went on to say, this is not appropriate for 56. I have to make factual findings. I'm converting it to 52. And that's what he did. This case is before this court on a Rule 52 motion, and any argument that it shouldn't have been was way below. And more importantly, there's no prejudice. What would they have done differently? If Judge Schrenga had said, we're going to call this 52, are they going to file different briefs? Are they going to bring in different evidence? No. The evidence is there, what is before the court in that closed record. There is no dispute about what that record was. Judge Schrenga said, I need to make factual findings, credibility findings, medical findings, which of the doctors are more persuasive, the law, and he did so. And he did it under Rule 52. Mr. Bachrach makes reference to that there was an error by counsel below with regard to his 56 findings. The lawyer made a motion for relief from that error, and the court granted it, and then denied the motion anyway. It wasn't even relevant. Mr. Bachrach also spoke about the Gallagher case and that the court erred because there had to be objectively satisfactory evidence. What he then does is try to equate that with objective evidence. But court after court, the DuPerry Court, the Cozy Court, and a court just recently, the District Court in Maryland, in the, we've cited, I'm not sure we've cited it, it's the Kristofiak, the Boston Mutual case, which came out after the briefing. Actually, no, it was before the briefing. Mr. Bachrach was the opposing counsel, and the court said, defendant has misread Gallagher. That case, in which de novo review was applicable, requires plaintiffs to submit objectively satisfactory evidence of disability, not objective evidence of disability. It's completely different. Under argument of counsel, someone who has severe migraines, debilitating migraines, there's no way to objectify that pain other than their subjective symptoms. Judge Schrenga very carefully went through this record. He noted 18 doctors on the plaintiff's side. He found them to be credible. Yes, there was one reference to embellishment by one of the doctors, but he also said he believed these were probably symptoms of post-concussive migraines. He didn't discount that she had a problem. He mentioned embellishment. One word out of 6,000 pages, that's their argument why the plaintiff should lose. One word, embellishment, in one record. Another point which I think the court should be focused on is that one of the peer reviewers retained by Reliance Standard, Dr. Damian, who they relied upon to deny this claim, reported to Reliance Standard, Ms. Techman can work. And that's what they reported to Ms. Techman. Dr. Damian said, you can work. What they didn't say is the rest of his sentence, which said, as long as she's working in a location where there is no noise, no ambient noise, and no vibration. They left that out of their statement completely. They left it out of their statement so this court, I think it's disingenuous to have them take their own peer reviewer. And if you look at the record, they went back to him twice to try and get addendums from him. Like, are you really saying that? Do you really mean that she can only work in an environment with no ambient noise? And his response was, yes, that's what I mean. What did they do with that? They did nothing but ignore it. Did they take it to a vocation expert and say, well, can this environment be provided to her? They didn't. Now, we can only speculate why. My speculation is because Reliance is a self-motivated, financially interested insurance company that was looking for a way not to pay this claim. And they knew that if they took that statement by their own peer reviewer to a vocational expert, they're going to say, that's an environment that is not possible for any reasonable employer to provide. This was a woman who was motivated to work. This was an employer who was motivated to keep her, but they couldn't provide that environment. It wasn't possible. There was no clear error here. There was no error at all. If you look at this case, clear error, de novo, if you were to look at under an abuse of discretion standard, the correct decision was made by the district court that the overwhelming evidence supported that this woman was disabled. I don't know what Mr. Bachrach will say in rebuttal. They've made this argument that we don't cover people's locations. Well, once again, their arguments misstate the facts. No one said that she can't work because the location she was in prevented her from working. What happened was she got better, she moved to a particular environment that caused a severe relapse. And that relapse stayed in effect well after she stopped working. The record shows that there was a lawnmower nearby and she fainted when she was at home from the noise. All of her doctors found her credible. The word embellishment, you can't take a 6,000-page record, find one doctor that says maybe one of her symptoms is embellished, and that means she's not disabled. Dr. Prasad, a neurologist, was recommending surgery for the problems he thought were there. That is not somebody who thinks that their patient is embellishing things. They're not going to operate on, I don't know if it's the brain or the ear, because she's making up symptoms. Unless the court has more questions, I will reserve my time if I can. I don't think I need to, but I'll stop unless the court has questions.
Thank you, Mr. Bachrach.
Cantor. He's Mr. Bachrach.
I'm sorry, I'm looking at a sheet back and forth, so when you said reserve time, you don't have any time reserved.
Well, I'm
This will be
sorry.
the last we're going to see of you today.
No.
That's what I mean.
Okay. Unless the court has more questions, I will sit down.
Great.
Thank you, Your Honor.
We're here for Mr. Bachrach.
Thank you, Your Honor.
Confusion.
I just want to refer back to the Shoup case. Court stated on page 706, upon conducting a de novo review of the record, we conclude that Shoup was disabled. So they conducted their own de novo review of the record, made their own factual findings.
You know, that's granted. The Shoup case does, it's kind of interesting the way the case goes, but, you know, the issue really before us is what prohibits a district court from using Rule 52? Even if this is a way you can do it, even if this court on review can look at a summary judgment. When you look at the Johnson case dealt with where the court had granted summary judgment. And then it came up for review, and then the court moved from there. It didn't change anything, and even no matter how you look at it, I guess at the end of the day, you'd be okay if we just take this case now and just do a de novo review. All you're interested, You want us to do a de novo review of it instead of looking at these findings for clear error, which we do under Rule 52. I suppose, and as I look at the Shoup case, I'm trying to determine, did that court really resolve disputed issues of fact? Because even in summary judgment, you get to a de novo review where the facts are undisputed. Then you get to the question of law. Does that lead to the legal determination on the summary judgment? Does it rule in favor of the defendant or the rule there? That's what a de novo review. But what you want is factual de novo review because of the record, the language says of the record.
And
The de novo review of the record. I got it.
That's exactly what the court did
But,
there.
someone has to clean this up because I don't think we're going to take on this job of reviewing these cases every time they come up on the record. That's a trial judge's. If we're going to do that, what we need a trial judge to do? He might as well just send it up and say, Judge, just do a de novo review of it. We don't need to do it.
Because
we don't do that. If it's a summary judgment, it will be upon the facts. And if the facts come up here undisputed, we then we determine as a matter of de novo, is this a law correct, moving this direction for the plaintiff, or does it go for the defendant on those undisputed facts? Got to make some sense out of this. I tell you. Well, because but the ultimate question, I'll go back to it. What prohibits a trial court from saying denial of summary judgment? I'm going to conduct a Rule 52 review, and I'm going to make findings of fact. And boom, here's the result.
I would say it's this court's precedent. That's what does it.
Which
It's
precedent?
Which precedent?
The Johnson case, the Shoup case.
When were those
and
cases
numerous
decided?
cases before then.
When were they decided?
But Your Honor, well, Shoup
Answer
was
my
last
question.
year.
When were those cases decided?
Shoup was
You're
last
talking the Shoup case just got decided in 21?
Yes.
So
Your
you're
Honor.
saying in 21, we set a policy that had never before been set?
No,
that was
it
different.
was said in Johnson, it was said in the Cozy case, it's been said repeatedly. But Your Honor, let me.
I'm sorry, you think though in those cases, the court held district courts may not conduct Rule 52 bench trials in ERISA cases?
It was never explicitly stated this is the
Okay.
way it's been done for years and years
But
and
it's
years.
not the only way it's been done. District courts
is.
in this circuit have been doing Rule 52 bench trials too.
In ERISA cases, the
Yes.
district court could only find one, an Eastern District of Virginia case that was
The
in the
Newman
2000s.
case?
Excuse me?
Yeah.
There was just the one.
Ellis's case.
I do need to move on because there are a number of incorrect statements that were made by counsel. We're not just relying on the fact that there was embellished, and this isn't a migraine case. There is testing for cognitive problems. There is testing for vestibulopathy, and none of it corroborated these symptoms. And counsel said that his client passed out because the lawnmower was operating a block away, and yet the same person is able to drive herself to and from her examinations. And clearly there are going to be vibrations doing that. If she's passing out, how could she be driving? Her own doctor, one of her other doctors says, this looks like a mental illness to me. And she never sought that treatment because she was embedded with the fact that this was physical. And that does matter under the policy. Counsel also argued that the new building she moved into exacerbated her symptoms, and therefore, even after she was no longer there, she couldn't work. That's not what she told her doctors. It's in our brief. She said working in that new building was the problem. And our policy says that a specific location cannot be the basis for a disability claim. We also have this district court judge failed to not only follow Gallagher and Shoup as far as objective evidence, but the court also failed to follow the Supreme Court in the case of Black & Decker versus Nord, which says that you can't place undue weight on the opinion of a treating physician. If I may finish this point, Your Honor?
May.
Thank you, Your Honor. So in Black & Decker, again, the Supreme Court stated that you cannot require a plan to offer special weight to the opinion of a treating physician. But the district court said just that here, that it was giving special weight to the opinion of the treating doctors because they actually saw her. And in a different case, in Griffin versus Hartford Life, this court stated again, no, that's wrong. It's the claimant's burden. There is no obligation to conduct an IME.
Well,
So
thank you, Mr. Blackrock. We appreciate your argument, appreciate the argument of counsel here today. Counsel, I ask, do you have any further questions or inquiries this time? We thank both of you for your presence here. As I said before, we normally would come down and shake your hands. We just won't do so now out of the safety and for your safety and ours in terms of what we all know is existing now. But we do anticipate and hope that that practice will resume at some times in the near future. At this time, the court is going to adjourn for the day and until we resume court again in the morning.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.